All attendees are in listen-only mode.
Well, good morning, everybody on the West Coast, and good afternoon for all you folks on the East Coast. Thank you for joining us today. My name is Deb Erdman, and I am Vice President and Trust Officer with Peak Trust Company, formerly known as Alaska Trust Company. We are very pleased to sponsor today's presentation, Special Needs Planning for the Disabled. Never, ever give money away. So before we introduce our speaker, I have a couple housekeeping items for everyone. Just a note, today's webinar will be recorded and a replay will be sent to all of you after the presentation. Also, feel free to post your questions in the box on the right-hand side of the screen. Everyone's going to be muted during this session, and we will hold a Q&A at the end. So now on to our presenter. Laura Stuberud is an esteemed estate and family law attorney with over 20 years of experience in Nevada. After graduating from UCLA, she studied law at Southwestern University School of Law. She is admitted to the bars in the states of Nevada and California. For the past 10 years, Ms. Stuberud has practiced primarily in the areas of estate planning, wills, trusts, planning for the disabled, and probate administration. She's published several articles on trust for the disabled and particularly enjoys working with families, focusing on their future to provide a sense of security and peace of mind. She has lectured on estate planning and probate to many groups in Southern Nevada, including the City of North Las Vegas, People's Law, Nevada PEP, and Multiple Sclerosis Society. So it is my pleasure to turn it over to Laura.
Great, thank you, Deb. It's my pleasure to be here. Hopefully I'll be able to introduce you to some new information or reinforce what you already know. The majority of information that I'm going to give is based upon federal law and Nevada law, which pretty much just tracks federal law. It's important to know that each state handles these topics a little bit differently. Some states are more easy to work with than others. Nevada in particular is very difficult when it comes to helping people receive and maintain public benefits. So if you have any state-specific questions other than Nevada, I certainly urge you, if you're not an attorney, to contact an attorney who practices in this area in your state to get more detailed information if you have any questions. So, as Deb said, I've been practicing in this area mostly for the last 15 years exclusively in the areas dealing with elderly and disabled people. And I do a lot of work for, believe it or not, personal injury attorneys who run into clients who are under disabilities or may become disabled and will either need to protect benefits they already are on or may need to receive them in the future. So if you're an attorney, oh, there we go. So if you're an attorney, obviously you need to be aware of the type of clients that you're dealing with, but also if you're in any kind of financial industry dealing with the public, people who want to come and speak with you, you need to understand a big picture of your client and what their needs are. Some public benefits are granted to a client based upon their disability status, and also their income or their financial resources. And a disabled client who receives money or property from a settlement, judgment, gift, or inheritance could risk losing important public benefits. So the type of people that we're talking about are people who have been determined to be disabled or may become disabled in the future. And this can be adults, children, anybody. Whether a person is disabled is determined by the Social Security Administration. And in order to be found disabled, they have to be unable to engage in substantial gainful activity by reason of any medically determined physical or mental impairment that is expected to result in death or has lasted or can be expected to last for a period of 12 months. And it's not always obvious. You know, somebody comes in with a bad back and you may think they're disabled, but they may not qualify under that definition. It's actually a pretty onerous definition. They may come in a wheelchair. They may come in with a walker. It could be temporary. Doesn't mean they're disabled. Also, you may have clients where you don't see the disability. There could be a disability due to a mental impairment. You'll sometimes have a traumatic brain injury or somebody who suffers from a developmental or mental disability. You can also have clients who suffer from silent illnesses that have rendered them disabled. And I always try to remind myself when I see somebody parked in a handicap spot who doesn't appear to be handicapped that they may very well be one of these people with a silent illness that renders them unable to work. When a client comes to you, you have to be able to determine if they have a disability. And that may not be easy to do. That's something to just keep in mind. The type of benefits that we talk about for the disabled are usually based on federal law, but some are also based on state law. We're talking about Social Security disability, supplemental security income, Medicare, Medicaid, VA disability, VA pension, subsidized housing, and you may also have food stamps and those types of things that come from local governments. In order, you need to determine or you need to understand how people receive money from these different programs and what the different programs are. Social Security Disability Insurance we call SSDI. This program provides cash benefits for disabled individuals who have accumulated enough work credits. They have to be disabled under that definition that was shown before. They have to have worked 40 quarters, 10 of which must be within 10 years of disability. This is not a need-based program, so it's a program that you earn. And if you receive SSDI, you will receive Medicare eventually. The standard for when you receive the Medicare is 24 months after you've been determined to be disabled. So when I talk to clients about this program, I usually put it in terms of this is taking your Social Security early because you're taking it before you would qualify either at 65 or 67 or whatever that number is going to be. So it's an early Social Security. The amount of money that you take obviously would be less than you would get if you had reached full retirement. But for a lot of people, they need to get on Medicare earlier because of their medical needs. The next federal program is Supplemental Security Income, SSI. These are for individuals who have been determined to be disabled, but who have not earned enough credit to qualify for Social Security. These individuals generally have very low income and no assets. It's obviously need-based because it's for the very low income, and they will receive Medicaid within 24 months of having been determined to be disabled. SSI provides a monthly subsistence level cash grant for food, clothing, and shelter. In 2016, a disabled person can have only $21.99 in monthly income and $2,000 in assets. That number goes up to $2,025 of income for 2017. So as you can see, it's not a huge amount of income they can get monthly from any source to enable them to qualify. Now, of course, most people who are disabled aren't making that kind of money and income anyway. But when we talk about elderly people, they may very well have that amount of income coming from a pension or something like that where they worked at some point in time. And the main difference between SSDI and SSI, and it's a very important difference, is one is need-based and one isn't. And that will be important for you to understand the type of client that you're working with, especially since some people can receive both of these programs. The next benefit that we look at is Veterans Disability Compensation. Now, there's two types of veterans programs out there. There's the disability compensation and there's the pension. The disability compensation is for disabled veterans in cases where their disease or injury was incurred or aggravated while on active duty in the military. It doesn't have to be combat related. It just happened while they were active. And it is not based on financial need. So this can be, we have a client right now who has injury due to Agent Orange exposure during Vietnam. Of course, he's older now, but he's been disabled for some time. That gives him a disability compensation from the military. The other benefit that the veterans can get is VA pension, which used to be known as, or is sometimes referred to as, aid in attendance. It's for low-income veterans and their spouses, believe it or not, who are permanently and totally disabled. Unlike the compensation program, the pension benefit does not require that the disability be connected to the time the veteran was on active duty. So oftentimes we're talking about the elderly. Of course, you have to be over the age of 65 in order to get this program. Again, totally or permanently disabled, in a nursing home or receiving skilled care, generally is the point at which these people have reached. And they're either receiving SSDI or SSI. Now, for clients who apply for aid in attendance or SSI or SSDI, both programs require that you apply for the other. So they're kind of competing not to provide the benefit. The requirements for veterans pension are not as defined as they are for SSI. Remember, under SSI, you needed to have limited assets of only $2,000 or income of $21.99. We're not quite sure what it is for veterans pension. The general perception among practitioners is that a recipient cannot have more than $80,000 in assets and limited or no income. But the more advanced age they are, the less money they can have. So this is really almost like an end-of-life provision. If you have a veteran who is deceased, but they have a surviving spouse, they may also qualify for this benefit. This can be the difference, this particular financial benefit can be the difference between a client being able to stay in their home with some care versus being forced into a Medicaid facility before they really need to go there. So it can be a very important benefit. Currently, Congress is looking to bring the VA pension eligibility in line with SSI, which would certainly make it easier to know which clients are going to get which benefit, but may not be very helpful in the long run since they're actually competing types of benefits. If you get one, you generally can't get the other because it takes you over the income limit. Then we talk about Medicaid versus Medicare. These are important distinctions. Medicaid is a federal benefit or insurance program which provides medical coverage. It's administered by the states, and it's available to the disabled and low income. Medicare, on the other hand, is medical insurance provided by the federal government to those who are over the age of 65 or under who are disabled, but who have paid into the system, like we discussed before. Very important for you to understand the difference between the two types of Medicaid that we see, especially now in light of the fact that the qualification for Medicaid for those who are not disabled has certainly changed. We still call it Medicaid for the low income. These are for people that are under the age of 65. Generally, they have very limited resources, very limited income. Under the Affordable Care Act, the number of people who are eligible for this type of Medicaid certainly has risen. In Nevada, Medicaid for poor or low income is available to those with incomes at 138% of the poverty level, which is this year at $16,243 for a single person and $33,365 for a family. So you can see that more people fall into the Medicaid eligibility requirement. And I do get a lot of phone calls from people who are receiving this type of Medicaid. And it's important to make the distinction because there's a different effect on Medicaid for people in this program when they receive any type of monetary award. And we'll get to that. Medicaid for the disabled is more restrictive, obviously. It's based upon those same income limits and resource limits as SSI, Supplemental Security Income, at least in the state of Nevada. Now, some states will provide more benefit to people who qualify for SSI or don't qualify for SSI, but they may give them Medicaid based upon their own state determination. States like Nevada, New Mexico, states that don't have a high income tax rate generally are much more restrictive in who they're going to be giving Medicaid to. And why is Medicaid important? Well, let's go back. Resource limits. What does that mean? You can only have $2,000 in assets, $3,000 for a married couple. Medicaid and SSI are going to look at all of the assets that a person has in any form. Some assets they don't care about, which are your home, a car, burial plots, and personal property. Unless, of course, you have very expensive art or a client has a lot of investments in antiques and things like that that have a significant monetary value, then they're going to be looking at that. Almost all other assets will disqualify an individual from obtaining or maintaining benefits. The income limit in 2016 is $2,199 per month, and that's combined. So that includes a spouse's income. So that can be the trigger to really keep somebody off of benefits. In 2017, the number goes up to $2,025 a month. And as I stated before, some states may offer Medicaid benefits that are not based on such restricted income and asset limits. Medicaid is important, and you'll get clients who come in and say, well, I really want to keep my Medicaid. And it's because Medicaid pays for things that may be difficult to come by through insurance or Medicare. Medicaid will cover skilled home care services, and Medicare doesn't pay for those. It covers laboratory and x-ray services, doctor visits, surgery, hospital care, physical therapy, transportation, prescriptions, medical equipment and supplies that may not be covered by Medicare, nursing homes, which are not covered by Medicare. So, and also Medicaid can pay the Medicare premium for a low-income individual. So for some people who come into some money, either through inheritance or any type of financial award, that can be eaten up very quickly if you have somebody who needs some of these services and it's not being provided for, or the out-of-pocket expense, the co-pays, the premiums for those insurance policies, the out-of-pocket costs can really eat into money. So they may want to be looking at getting on Medicaid or maintaining Medicaid to protect some of those assets that they are receiving. Some of the other benefits that you'll encounter may be subsidized housing through the the HUD department of the federal government. Under the Section 8 program, they give vouchers to low-income families to make up the difference between the maximum rent for an area and what the families can afford. So that's another low-income program, plus public housing, which may be managed by local authorities. And generally, income is limited to 50 to 80% of the median area income, which, of course, will vary from state to state, county to county, and probably even city to city. Other programs that you might hear about is the SNAP, which is the food stamps, or the temporary assistance for needy families, which again is a temporary program to help people who have 9 times out of 10 had some sort of sudden loss of income. Benefits that would be lost by awards of money would be supplemental security income, Medicaid for the disabled, and to some extent Medicaid for everybody, and VA pension and subsidized housing. So how does the receipt of these assets affect the benefits? Any money that's received can reduce or eliminate a recipient's benefits. It can be judgment from litigation, structured settlements or any type of settlement from litigation, insurance payouts, annuity payments, gifts, inheritance, any form of monetary or property award can reduce or eliminate a benefit. And like I said, most clients worry about losing their Medicaid benefits more than anything because, as we know, medical costs really can eat into somebody's assets. Knowing the benefits that your client receives or is eligible to receive is probably one of the most difficult things we encounter because people will be talking to you and maybe they want to sit there and leave some money to a friend of theirs or a family member, and the question is, well, what benefits are they on? And so they say, I don't know, Social Security as a general umbrella. Well, we know that that's not enough information. What Social Security program do we have? So some of the questions to ask is, what kind of medical coverage are they getting? If they're on SSI versus SSDI, we know that SSDI gives you Medicare and SSI gives you Medicaid. So if someone says, well, I'm on disability and I get Medicare, that's a little bit of a clue. Maybe it's the SSDI program, and you don't have to worry about what kind of money they have. If they still say, I don't know, and I'm getting Medicare and Medicaid, well, then you have another set of questions you have to ask. Some of it is, what are your assets? Age is important. What's the nature of the disability? Sometimes we ask, well, how much are you getting? Again, they don't always know. Most of them will. If you're on SSI, this year they're getting the maximum of $733 per month, or $1,100 where you have a spouse who's also disabled. That's going up to $735 a month next year, and a corresponding increase for married disabled spouses. Social Security disability income or insurance is based upon the amount paid into Social Security while working. So here's the tricky part. You can actually be getting both. If you're getting SSDI and it doesn't take you to that maximum amount of $21.99, you could be getting some more money from SSI. You can be getting SSI and not get the full $733 because there's a reduction for certain expenses, for housing and things like that that you're not paying for. So just asking the amount of money that's being received often isn't good enough either. You have to ask specific questions. The best thing you can do is get a copy of the award letter from Social Security and the Veterans Administration. Now, if they've been on these benefits for a long time, they're not going to have the original, but if you get the most recent letter and they get one every year, you should be able to glean some information from that. It gets a little crazy sometimes in trying to make this determination. Clients receiving only Social Security, disability, and Medicare will not lose the benefits no matter how much money they receive. That's why it's so important to know what it is that they are receiving. Okay, how to protect benefits. This is where most practitioners come in, whether you're going to be an attorney or a financial advisor or an accountant. These are the things you really need to kind of understand that are available to protect benefits. As I mentioned, I get a lot of clients who come in who are receiving personal injury awards of a modest amount by the time the attorneys are paid and the costs are paid. So we talk about what's the best way to protect what they get. The probably easiest way, although believe it or not, if people don't have a lot of money, they don't really want to do this, is to spend down what they're receiving until they only have $2,000 in assets left. Okay. Medicaid is lost in the month that the money is received. So if someone is getting a modest amount of money, I have someone who's inheriting $10,000. So we say, okay, you're going to lose $10,000 supposedly in the month it's received. Practically, it's the next month or the month in which you tell Medicaid that you've received this money, or SSI. So we try and put in a plan of how to spend that down quickly so you don't lose your benefits for a long period of time. One is to purchase exempt assets, which is a house, a vehicle, household goods, and personal effects. Sometimes you'll have somebody who's living in group housing or something like that, and they just want some stuff. And if it's a modest amount of money, we have it identified, they get the money, it's purchased immediately. We save enough money to handle the bills that they're losing as a result of loss of Medicaid, and then they're good. You can prepay funeral or burial expenses, pay or prepay bills and recurring expenses. I've had people pay for insurance premiums up front for a year that they would normally only pay monthly on for a car. You can pay your rent in advance. Anything that's kind of recurring, it can be paid in advance. Make repairs or modifications on a home or car. That's a great way to spend down money on needed repairs to a home or a car. I did have somebody who was getting a small amount of money, and we decided to just put in a new water heater because the water heater was old, and they wouldn't be able to make a repair if the water heater went. So what a great way to keep them eligible and get them what they needed. They can enter into personal service contracts for people who can come in and take care of them. Dental work, because Medicaid and Medicare, nobody pays for dental work. And none of these people have insurance, and a lot of people will forget to take care of their teeth, which can lead to significant health problems in and of itself. So that's something I always encourage, and they look at me like, oh, I never thought of that. Well, what a great way to spend your money. Travel. Some people want to go see their family. They haven't seen them for a long time. I had one gal who couldn't wait to get her money so she could go on a cruise, because it wasn't going to be enough to take her to last a long time, but it was enough that she was going to take her 3-day cruise to Mexico and have a nice vacation. So those are great ways to spend down the money. As long as you make sure they don't give their money away. That is a big no-no, because that can render somebody completely ineligible for a period of time that can be significant, and we'll get to that. Oh, I guess I can talk about that now. Actually, that's on my next part of my discussion. When we talk about giving money away, why is that such a big problem? If you give money away, your loss of benefit is longer, particularly for Medicaid. Medicaid looks back 5 years to see what you've done with your money. And if you have someone who has the money and they come into you, which happens all the time, and say, well, I want to give money to my grandchild for college, I want to give money to my parents, I want to give money to my children, and they are elderly or they are disabled, the red flag is don't give the money away, because Medicaid's going to look back for 5 years and see what you did. And you're going to lose your benefit. The length of time you lose the benefit is based upon the amount gifted divided by the average private pay cost of a nursing home in Nevada and in every other state. So, for example, if the average monthly cost of care is determined to be $5,000 and a person gives away property worth $100,000, then the individual will be ineligible for benefits for 20 months. And that can be significant. Now, some people, if they have enough assets, that's great. If you've got enough money to cover the 20 months worth of private care, then we don't worry about it. But for all of us, the objective is to keep the money going as long as possible before we need benefits, or to preserve the benefits that they're already on. One of the other ways we protect assets that come into a disabled person, if they're under the age of 65, And I realize I'm going back and forth between Medicaid and SSI, but we look at it more as a global type of environment. Medicaid usually being the more important, because you can qualify for SSI as a disabled person, but not qualify on the income basis. You have too much income. But that doesn't mean you won't necessarily qualify for getting a Medicaid benefit depending upon your jurisdiction. So we're always looking at it more from a Medicaid perspective. So one of the things we can do under federal law to protect the eligibility is by creating irrevocable trusts. Under 42 U.S.C. 1396 PD4A, we call these D4A trusts, a person can put their own money into an irrevocable trust. So you have a client who is receiving money from any source, they're disabled, they don't want to lose their benefit, or they may get a benefit in the future. It's not, we're not talking about millions of dollars per se, sometimes we are. They want to protect it. So what do? We create a special needs trust, and we can put the money in there. The problem with that, oftentimes, in my practice, is that the trust has to be established by a parent, legal guardian, or a court. At this time, it cannot be created by the disabled person themselves. That's one of the problems practitioners have, is because so many of our disabled persons are not mentally disabled. They're only physically disabled. So they should be able to create these trusts themselves. And in fact, Congress is going to be passing a new law this week, hopefully tomorrow, that will allow disabled people to create their own irrevocable trust. But at this time, it has to be established by a parent, legal guardian, or a court. The money placed in there can only be used for the benefit of the disabled person, which Social Security and Medicaid are very, very particular about the language in these trusts and how that money is spent. And the remaining money at the death of the disabled person pays back Medicaid, not SSI. They don't have a payback provision, but Medicaid in each state has a payback provision for benefits provided during the disabled person's lifetime. Very important to remember, these apply to people under the age of 65. And if Medicaid is paid back fully and there's any money left, then whatever's left over can go to heirs or charities or whatever was decided. Another method under that same statute is by doing something called a pooled trust. This is something that the disabled person can do themselves with their own money. They can place it into a pooled trust, which is a trust that's managed by a nonprofit organization. Generally, it's a master trust agreement, and each individual signs a joinder agreement. And they place their money with this organization. The organization has trust officers or caseworkers that work with the disabled person for distribution. And depending on the state, money remaining at death has to be used to repay Medicaid. Some states don't have that requirement. Nevada does. Others don't, in which case it can either go to the heirs or it just stays with the nonprofit organization, depending upon the trust agreement itself. Nevada, unfortunately, does not have an in-state pooled trust, which makes it a little bit tricky for some of our clients. There are other trust companies, pooled trust companies, that are acceptable to the state of Nevada, but because of the distance between the client and the caseworker, sometimes that's a little bit difficult because a benefit recipient cannot actually receive cash in hand. So unless they want something that's easy for the pooled trust company to purchase, it can be very difficult. I had a client who says, well, I want to buy a car, and it's not a lot of money in the pooled trust. And the caseworker says, well, you can buy a car, but this is all you get for the car. And she wasn't happy, and we tried to explain to her, okay, you want a car, but then now they have to keep money to pay for the insurance, the maintenance. How are you going to pay for the gas? Did you get enough in SSI to pay for the gas? Because they're not going to be able to do that for you. So there's lots of discussion that has to go on before people really put their money in these pooled trusts. but I do know in other states where the pooled trust is local that they're very successful. So they're certainly worth considering. One of the new things that we have as a tool for people who are receiving money but on benefits is called the ABLE account. It stands for Achieving a Better Life Experience. This legislation was passed in 2014. It is currently only available in 4 states, although I know Nevada and Alaska will have these accounts up and running in 2017. Under this act, you have to have a disabled person who has been disabled before the age of 26. They don't have to actually have a disability determination before the age of 26, but they have to have been disabled. So if you have someone who was in a disabling accident when they were young, blind, deaf, that type of thing, it's pretty easy. If Social Security or Medicaid ask for proof, they would have to provide proof. Again, this is nice because the individual can establish it themselves. You're going to go to a particular bank that offers these accounts. It's supposed to run like a 529 plan, very similar to that. Establish the account. Anybody can contribute to it, but you can only put $14,000 a year into it, up to a total of $100,000. The nice thing about that, again, is if you have a small amount of money, somebody gets a small inheritance or a small recovery, this is a great way for them to have control and not go to a lot of expense to create a trust. The one caveat to that is that distributions from that can only be for qualified disability expenses. Now, that's going to be something that's going to be determined by each state under this Medicaid program. What does that mean? What's a qualified disability expense? It's going to be for, currently under the federal law, it's education, housing, transportation, employment, training, and support, assistive technology and related services, health, prevention and wellness, financial management and administrative services, legal fees, funeral and burial, and basic living expenses. That sounds really broad, but depending on how the state is going to look at each of these items, it may not be as broad as we think. That's pretty broad. The only thing I see you can't do is go on a vacation with it. So we'll see where that goes. I don't have enough information, again, because Nevada doesn't have that. And in these accounts, the state is reimbursed upon death, unless the state decides otherwise. Again, Nevada, we were supposed to have this up and running in October. It's run by the State Treasury Department. When I talked to them last month, they said December. I haven't received any notice on how these are going to work yet. Currently, the only states offering these accounts are Nebraska, Michigan, Ohio, and Florida. I understand a couple of these states are allowing non-residents to open the accounts. So if you have a client who's interested in that, there is actually a website, and I don't have that written down, but it's basically just a group that's working on these ABLE accounts. And they have a lot more information if you have a client who's interested in looking into that. Things that come out that I get called on frequently are structured settlements. A lot of high recovery personal injury cases will result in a structured settlement, either because we don't want a lot of money going into the hands of the recipient or the trustee of a trust or things like that, a little bit more control. It's basically, I'm sure you know, it's an annuity that pays out monthly. It can be used in conjunction with a special needs trust to fund the trust. It has tax-free growth, which makes it beneficial. You can control what goes into a trust. You can also fund an ABLE account with it. So what's really interesting about these structured settlements is that some of it can go to a special needs trust, some of it can be used for an ABLE account. And the beauty of the ABLE account is that it lets the disabled person have some sort of control. A lot of times when they come in to discuss these trusts, They don't like the fact that they have to have a third party controlling their money, and they have to go to when they want something. They find that, you know, if all you have is a physical disability and you're able to get around, you don't want to give up all of that. So I've had people who just said, okay, I'll just take my money, go off the benefits, spend it all, and then go back on, you know, 5 years from now, because they've never had it and they want to have control over it. So that's one of the great things with these ABLE accounts and structured settlements. The third-party supplemental needs trust, this is a trust that is created by someone other than the disabled person. Loss of benefits through inheritance can be avoided if the person who is giving money establishes a special needs trust for the benefit of the disabled person. We see this a lot with grandparents who have a disabled grandchild, and they want to make sure that they don't lose their benefits, or they want to make sure they don't interfere, or the person they're giving it to isn't really qualified or competent to manage the money. So we create the trust. It can either be created through a person's estate plan. So when, you know, we do a revocable living trust for a couple, they have a disabled child, we'll make the special needs trust established upon the death of both of the trustors. Or it can be created by a grandparent. It can also be created at this moment right now and funded with something. Whether it's, you know, instead of doing a 529 contribution that grandparents will often make, they can make a contribution during their lifetime to a special needs trust for that grandchild, and then that grandchild has money. For clients who don't have a lot of money, because it's expensive taking care of a disabled child, a lot of times we will fund it with a life insurance policy. And so that will pay into the special needs trust upon the parent's death. That's probably the least expensive way to fund a special needs trust for people on modest incomes, but it works great. And there's no payback requirement because it's not the disabled person's money. There's a third person in charge of it, and then the person who establishes that trust gets to decide what happens with the money if there's any left at the time the disabled person passes away. So it's just another great estate planning tool for people. As an estate planning attorney, and even as a financial advisor, it's really important to ask the client the nature of their heirs and what, you know, some people will say, well, they're autistic. Well, that's a very broad statement to me, so I will delve into that a little bit more. Sometimes they're very young, they don't know what the child will be capable of doing. So we'll recommend the special needs trust through their own estate plan to manage that. And if it turns out that they don't need it, it's as they get older and you see that your grandchild is going to be capable of caring for themselves, they can amend it, they can get rid of it. So it's a really great estate planning tool for clients. Here are the traps that a lot of people don't think about. Again, it's the gifting. 60-month look-back period. And for a lot of states like Nevada, where we're very tight on money, they look at pretty much everything. And they don't care if you engage in a regular gifting program every year. It can render the person ineligible for the benefit. So it's very, very difficult to explain to clients sometimes you can't give the money away. And I get a lot of people say, well, I'll give it to them, and then if I need it, they'll give it back. Well, as estate planning attorneys, we know that once you give your money away, good luck. Because we know, we're always the negative Nelly when it comes. Everybody says, oh, my kids love each other. They get along. We're a great family. And I'm like, yeah, but they get married. They have significant others. You never know what's going to happen, right? So we have to play that role for them. The other thing for estate planning and financial techniques that are problematic are annuities. A lot of people don't understand that an annuity can render somebody ineligible for Medicaid or SSI. One, because the transfer when you purchase the annuity is a transfer for assets, or the transfer that triggers the 60-month look-back period. The other is the amount of income that comes out of it. And I know a lot of people like to use that in retirement, but they're very, very problematic, and as you know, they can be very expensive to get out of. So when people come to me and we look at their finances and they say, oh, I have an annuity, immediately it's a red flag. Or they say, well, we're meeting with our financial advisor, our insurance agent, we're discussing annuities. I immediately raise the flag. Wait a second, before you do that, you need to understand. And, you know, obviously if you're very wealthy, it doesn't really matter. But for people who aren't wealthy and maybe have $250,000, $500,000 in assets, and they have to spend down due to a catastrophic illness or a catastrophic injury that renders them disabled, an annuity can be a real problem. So from my perspective, I don't like them, but I know they're a great financial planning tool for a lot of people. A lot of people ask me now about Medicare set-aside accounts. For those of you who deal with personal injury actions, if somebody is on Medicare and they are injured, there is a division of opinion as to whether you have to create a special bank account and fund it with some money to take care of injury-related medical expenses. Otherwise, Medicare won't cover them. Those are not, believe it or not, I mean, if you have a Medicare set-aside account, it could be a disqualifying asset for purposes of special needs. We can put those inside of a special needs trust. They can be funded that way. And blocked accounts, for those people who, if you've inherited money and they're a minor, sometimes the money is put in a blocked account. If you have a personal injury settlement for a minor, it's put in a blocked account. A blocked account is an available asset for purposes of qualification for public benefits. And you'd have to go back to court, liquidate, spend it down for a child to receive public benefits. So those can be extremely negative. That's why I get a lot of calls from the personal injury attorneys, because hopefully they know that that is not a good thing for a child who suffered a debilitating type of injury, and they're representing them. So that's pretty much all I have. I hope there's some questions.
Flip to the next slide.
Flip to the next slide. There we go. Any questions? I'm happy to answer them.
Well, thank you, Laura. I really appreciate that. So if anyone has any questions, feel free. I can unmute you. If you will raise your hand, or if you want to just type in your question into the, off to the right-hand side, you can type in a little question there. Oh, I see we've got one in here. Hold on a moment. Let me pop you open here. And, okay, well, he just said, he's saying good morning.
Okay, there it is.
Here's a question for us. Hold on, let me pull it up for you, Laura.
Technical difficulties.
There we go.
Oh my.
We got all
lots
kinds
of questions.
We got
Goodness.
lots of questions.
Okay, the first question is, what if the individual does not meet the SSA definition of disability, but they're disabled and are limited in terms of their cognitive abilities? Can a special needs trust still be set up, or simply a trust with spendthrift provisions? Yes. Yes. I mean, we always set up these special needs trusts. What I usually do in that case is I'll create a trust. I'll put in the S&T language just in case, because if the person deteriorates in their abilities, we want that as a backup. The difference between the S&T, if it's a third party setting it up, we don't have to worry about the payback provision, so we can do anything we want with it. It's only if it's their money that it would be a payback provision. So it's much harder to just dish the money out if they don't need the public benefit. The next question. Can a 90-year-old on Medicaid receive both Social Security,
He's right here.
not SSDI, and SSI? Yes, they can. If they are poor, if their Social Security that they're receiving, they can receive a supplemental benefit from SSI.
Okay, and next one right here.
Can someone give to
Right here.
charitable donations such as a church? I'm not sure what that's oh, as far as gifting money away, no, they can't. You cannot gift to anybody or any entity. No, the $100,000 max, that's on the ABLE account.
Mm-hmm. Yep.
The $100,000 maximum contribution, no, it can continue to grow. They don't count that.
Okay, and here's the next question.
Annuities can be a problem. Okay, but Medicaid compliant annuities are, yes, can be used. A Medicaid compliant annuity can be used. We generally do that when we have somebody who has just too much money that's going to be eaten up. And so we'll create a special Medicaid compliant annuity. It has to be approved by the state in which you live, and then those are acceptable. The problems that we see are people who come into the office who already have the annuity, and generally it's not Medicaid compliant because they purchased it before they realized they were going to need any type of benefit. But yes, there are special Medicaid compliant annuities that work.
Here, right here.
Can we load a cash card for the special needs beneficiary? No, you cannot. That's like giving them cash. It's interesting. I am aware of a company, I can't think of the name off the top, that provides cards for these special needs beneficiaries or Medicaid beneficiaries. And in some states, those are permissible, but it's a special company, and you can limit what the card is used for. So it's almost like an internet card, and they can go on, say, Amazon, and they can make the purchase, but the bill is paid by the trustee of the trust. But just buying them a Visa cash card would not be acceptable, because then the trustee has no control over what's being spent.
Okay, here's the next question.
What dispositive provisions are allowed and not allowed in a special needs trust established by a third party? There are no limitations when it's a third party's money. That's one of the great benefits of it. It can be used for anything. It's just like doing an irrevocable trust for asset protection in a way. You're keeping control of it as the trustee of your money, or you're giving it to a third party. But because it's your money and not the disabled person's money, nobody can tell you what to spend your money on. So it can be used for anything.
Please repeat the qualifying.
Repeat the qualifying rules for an adult with a disability for Medicare. Okay, if you're receiving supplemental or you're receiving Social Security disability insurance, which is Social Security based upon the fact that you paid into the system, and as a result of that type of Social Security you're receiving Medicare, there are no qualifying rules other than being disabled.
Next question.
Does not.
Right here, you mentioned that, Nevada.
Nevada does not have a pooled account for SNTs. Why not? I wish I knew. Nobody has decided to put one together. There was some talk about it, but we're a small state and nobody's really done it. So, well, a special needs trust versus a wholly discretionary trust. A special needs trust is created with the money that belongs to the disabled person. So, so that's the difference between a wholly discretionary trust, which would just be which is your own money, obviously, but the special needs trust has very limited language that is specific to Social Security and Medicare or Medicaid, because it can only be spent on certain things. And Medicaid and SSI, when we do these, we have to send them these trusts. So they're looking for very, very specific language. The wholly discretionary could potentially be too broad in its language.
Okay.
Okay.
We have 5 minutes left, Laura, so we've got a lot of questions here. So how many more do you want to take? And the rest we'll have to just respond in person.
Well, I'll answer as many as I can.
Okay, keep going.
Okay. Congress is looking at passing a bill concerning first-party SNTs. There is currently pending, the House of Representatives has passed, the Senate is hopefully going to pass something tomorrow called the CARE Act, which will allow a beneficiary who receives money to create their own special needs trust instead of requiring a parent, legal guardian, or court to do it. So that would be great for those people. That's yours. If a married person dies without a will or trust or children and has a disabled sibling, will the sibling be entitled to a portion of that person's self-owned and separate property? Inheritance, it says it's in California. Generally speaking, the laws of intestate succession would apply. And so if the law in California allows for that, then that's how that would be passed down. Okay, is it correct that the annual limit on contributions to able accounts limits their usefulness? It might, but it can be used in conjunction with other types of planning. But for somebody who's just receiving a small inheritance, it can be great because then they can have something without having to do a quick spend down and lose benefits. How does Medicaid look back apply to life estates? That's going to be specific to your state in Ohio or wherever you are. Yes, I saw that case too about that they can attach assets inside a life estate. Nevada, we don't use a lot of those. I don't know anybody who's using life estates, so unfortunately I can't give you a better answer. You would want to check with an attorney in your state. Thanks. Okay, in establishing third-party trust where the beneficiary has no ownership rights and subject to a specific state law, be found these trusts breached when a beneficiary is involved in a divorce. I wish I could answer that. I have not been involved in that at all. It's going to depend upon, that's another jurisdictional question, and I don't do divorce law, so I don't really know how to answer that. I'm sorry. Okay. I'm going to go to the next one. If a disabled adult is not receiving SSDI but is receiving SSI, is there any way to qualify for Medicare under age 65? Not that I know of. They're going to go to Medicaid. If parents getting life insurance policy for benefit of disabled child, why not have it fund a third-party supplemental trust? Yes, they can do that. They can fund it. Absolutely. We don't wait until the child gets the money to fund the trust. We would use the, I see you're having the benefit, the life insurance. Yeah, we would establish the supplemental needs trust, and we would name that trust as the beneficiary of the life insurance policy. And then the last one, if a prospect is receiving a settlement from a medical malpractice, anything tied to initial claim has been covered with an. Okay, this is from a financial, they want to place in funds which will provide them with a monthly income stream. Well, unless you've got a tax issue that would be gifting, that would require gifting, you know, it's going to depend upon age, type of disability. My first comment is not to gift right away, but it's going to require obviously a greater evaluation. They're in their 60s. You know, if they've got enough money to cover everything and you plan out their potential medical needs so it doesn't look like they're going to need any type of Medicaid or public benefit, I mean, that's a lot of money, so most people don't. And if they're getting Medicare, as long as they've got enough money to cover their supplement, then I don't see a reason why not to do that. It's just you have to look at the overall situation and where it's going to lead them.
All right, that's it. Oh, we have one more.
That's for you.
Oh, that's right. Okay, perfect. So thank you, Laura. You are spot on your time. It is exactly straight up on the hour. We really appreciate that. She's gotten through miraculously every question, and anything that she has missed, we will respond to you via the message board. And also keep in mind that a recording of this webinar will be sent to you after this presentation. You can see on the screen that our contact information is listed there if you have any questions for Laura, and then also my name is listed there, Deb Erdman, and my email address and phone number, again, if you have any further questions. So thank all of you for attending today. We really appreciate it, and we hope you have a wonderful holiday season. Thank you.